SJC-12561, City Electric Supply Company v. Arch Insurance Company.
Mr. Day, good morning.
Good morning, Chief Justice. May it please the court. Justices, I want to start with a mea culpa. In our reply brief, I directed your attention to the Fidelity case. That was decided by a panel of the appeals court. I did not, however, note in the brief that the Fidelity case was a Rule 128 case and therefore may only be cited as persuasive authority. I also incorrectly stated that the Fidelity case was decided by the appeals court. What I should have said was that the case was decided by a panel of the appeals court. And so, in fact, I believe the Fidelity case is before this court right now on an application for a further appellate review. So I want to make clear right here at the outset what I should have made clear in my reply brief, that I cite Fidelity only as persuasive authority. But I do think that it is very persuasive authority, and it is right on point. Now, allow me to get right to the crux of this case. My client's complaint is a complaint to enforce a target lien bond under General Laws, Chapter 254, Section 14, the target bond section. This complaint is not, and never was, a complaint to enforce a mechanics lien under Section 5, which governs complaints to enforce mechanics liens. There is no requirement in anywhere in Section 14, the target bond section, that CES record a copy of its complaint at the Registry of Deeds. Indeed, there is no requirement anywhere in Chapter 254 that a claimant record a copy of a complaint to enforce a target bond at the Registry of Deeds.
What about Section 12's enforcement? Because that's also a bond enforcement when we're dealing with one of the, right?
Yes.
There's different kinds of 12. So why would you be required to file that complaint when, again, it's not a lien enforcement, right? It's a bond enforcement case too, right?
Right, Justice Kafker. Well, there are really two answers to that. The first, the easy answer, is because the legislature explicitly requires it in Section 12.
And I got that part.
Yeah.
That made sense to me. But
Okay.
what I had, there was a lot of your brief that I thought was very good on sort of the logic of not treating a bond enforcement like a lien enforcement, but the more general bond stuff in 12 seems to require you to file the complaint. Is it just because they required it by statute? Because that's inconsistent with sort of your principle that this is a bond enforcement case, not a lien enforcement case, so we should treat them differently.
Yes, Justice Kafker. There are actually two very different types of bonds. A Section 12 bond is a blanket lien bond. That's typically filed at the beginning of the case, and at the beginning of the construction project. It's typically in an amount that, to some degree, is guesswork. And so then, as the project goes on, what the blanket lien bond is there to do is to prevent any liens from attaching to the project. So, trying to jump into the legislature's mind and determine why they required that you record the complaint in the blanket lien bond situation and not in a Section 14 target bond situation, I would think the reason why is because there's a possibility that, for instance, you could have a $10 million project and a $10 million blanket lien bond, and then they could find, bedrock or groundwater 2 feet under, and all of a sudden you've got $15 million in claims on that. And so there's an interest to the title researcher in that case to find out whether or not this blanket lien bond is in a large enough sum to cover the project.
Can I press you on that, Westbrook, because I just want to understand it. Mm-hmm. So why would there be an interest in the title person? Because it wouldn't be a title case, even in your hypothetical, right? It would still be, would it be a lien case? Is it somehow become a lien case?
Well, if contractors, subcontractor suppliers are recording notices of contract on that project with a blanket lien bond in place, a Section 12 blanket lien bond in place, and you have notices of contract stating amounts in dispute of $11 million, and you have a $10 million blanket lien bond, I would think, and I can't say I'm an expert on this because it's a different type of bond from this case, but I would think that will be of interest to a title researcher because they'd be looking at it and saying, geez, there's not enough, that bond's not enough to protect the property. And so, whereas with a target bond, the situation we're in right now, a Section 14 target bond, the situation is very clear. The target bond targets the particular lien. So if your lien is for $1 million, that target bond has to be for $1 million. And so that was our argument in our brief. I think the chief argument is that, and the case law demonstrates that, even if you can't figure out why the legislature did it this particular way, if they have explicitly done it, and they've been explicit in Section 5, you have to record it. In Section 12, you have to record it. In Section 14, there is no recording requirement.
I get your statutory argument in the absence of the language, but would there be a particular public purpose for notice to be given, even to record a target bond?
I don't think there's any. I can't.
What would it do if someone researched at the Register of Deeds? Who would be impacted by it?
It is of, as I state in my brief, it is of no public purpose. It's I believe a useless exercise, because if you're a title researcher and you're at the Registry of Deeds and you're looking to say, okay, I got to notice a contract here. So I'm trying to find out if this property is lien free. Right. I got to notice a contract for $150,000, ABC company. So I keep looking, and then I see target bond, specifically referencing that lien, $150,000. I'm good. I don't need anything else. I don't need to see anything else at that point. And so to then, whether a complaint ends up getting, the parties may settle that case. The parties may end up in a lawsuit. Whether or not a complaint is filed on that lien, on that target bond, is of no interest to the title research. Either way, complaint, no complaint, either way, the title is clear.
Because
So
it's
there's
been
no
wiped out.
practical, I'm sorry,
Exactly.
no
Because
practical consequences.
there's no practical reason to record the complaint on the target bond. No practical reason whatsoever. It's of no interest to a title researcher. It doesn't affect the title to the property. Once that Section 14 states explicitly, once that target bond is recorded, the lien is dissolved. So if you're interested in whether or not this property is lien-free, you've got your answer. It's gone.
Under Section 12, if there's a blanket lien, which I know this is not, for, say, $1 million, and there emerge statement of claims for $10 million, what happens?
That's a great question, Chief Justice, and to be frank, I'm not prepared to answer it. I haven't researched it specifically. My sense is that the reason, as I said, the reason why you have to record it is because those $9 million in liens that are over the amount of the target lien, the blanket lien bond, would then attach to the property and affect the title of the property. I cannot cite a case saying that it's been interpreted that way, but that's what I would think with a Section 12.
And there's a possibility that the blanket lien may not protect you from a lien if it's inadequate in comparison to the
Correct,
claims.
Your Honor. And so I think that would be the practical reason why the legislature in Section 12 required that you record a copy of your complaint on a blanket lien bond, but not on a target lien bond.
Now, your brother in a moment is likely to stand before us, and he'll say, you're wrong, that there's no reference in Section 14 to this, because Section 14 expressly says that the target lien bond does not, quote, impair any defense which the obligors would have had in action to enforce the lien. And he's saying if it were a lien, the failure to file the complaint within 30 days would be a defense, and therefore, since that would be a defense, you have impaired the defense by denying him the opportunity to say you failed to file within 30 days.
Correct, Chief Justice Gantz, and I think that's I think that's their chief argument, and I think it's really what Arch Insurance is asking this court to do is make a giant leap from what the plain language of Section 14 that you just cited actually means and what they want it to mean. So let me explain that.
So what is could you explain what the plain language actually talks about?
Exactly. What the plain language is doing is it's saying that if you have a defense, to the lien, a substantive defense. So for instance, if Arch could say, and they cannot say this in this case because they do not have a substantive defense to this lien. The party that owes us the money, in their answer and suggestion of bankruptcy, said they're entitled to be paid. But if they could say, no, they didn't deliver the product, or the product was defective and we couldn't use any of it, they've got a substantive defense to the lien. What the legislature is doing with that language that Arch is now relying on is saying, if you're considering putting a target lien bond on this, don't worry about waiving your defenses. You're not going to waive the defense. If you've got a substantive defense to the lien, you've got that defense is preserved. The recording of the target bond does not impair your defense. That is plain language, that is easily understood, and it makes perfect sense. What Arch is asking you to do is take a giant leap and say, no, what that actually means is that it's creating these new procedural requirements, that language. How? I don't know. But that seems to be Arch's position. It's creating a new procedural requirement that a claimant on a target bond has to continue to take every step to perfect their mechanics lien after the lien has been dissolved by the target bond. That's what they're saying that language means. And they're saying if you don't interpret it that way, we're losing a defense. Arch Insurance does not have a right to a defense that it doesn't have. Arch does not have a defense that we didn't record a copy of our complaint on the mechanics lien, because the mechanics lien was dissolved before we ever got to that process. CES complied right to the letter of the law with every single requirement to perfect their mechanics lien. They filed their notice of contract, they filed it on time, it had all the required information in it. They did everything that they were supposed to do to preserve the mechanics lien. And then Arch came in and dissolved the lien with a target bond, which is what they can do. But at that point, they did not have a defense that we hadn't filed our complaint on the mechanics lien. Section 5, let me say this. They didn't have a defense to that because we didn't have a complaint on the mechanics lien. There is no mechanics lien. The mechanics lien is dissolved because they recorded a target bond.
And who would we be giving notice to in this context also? I mean, your brothers argued they're interested parties or interested people who need notice, but I don't understand who they are or who they would be hypothetically.
Notice, I mean, giving notice by recording?
Right.
Yeah, I mean, my short answer to that is I don't know either. I don't understand as I said, I think what Arch is suggesting is that all claimants on a target lien bond have to go through the useless exercise of recording their complaint in the Registry of Deeds on the bond to give notice to I don't know who. The Registry of Deeds is not a depository of all human knowledge. It's not a depository of all Superior Court pleadings. The Registry of Deeds is a depository for documents that affect the title to real property. The complaint on a target lien bond is a suit on a piece of paper. It's a suit on a bond. Under Section 5, it makes perfect sense to require it to be recorded at the Registry of Deeds, because under Section 5, you're suing on a lien, and that lien affects real property.
Can I ask you how this works in the real world? Because a point was made that these get recorded routinely.
Right, and I absolutely disagree. We absolutely do not concede that. And a couple of things, I'm glad you mentioned that, Justice Gaziano, and a couple of things I want to point out about that. First of all, the evidence of that is 4 complaints filed in this case. That does not establish a standard of the industry, even if you were inclined to take judicial notice that in this particular in this particular project, 4 complaints were recorded at the Registry of Deeds. If you look at the actual addendum, you will find that there are not 4 complaints in that addendum, in the pages that are cited, or anywhere in the addendum. There are 3 complaints, and 2 of them are Section 12 complaints. reference Section 12. So even that is not accurate if you look at what's in the addendum. But regardless, absolutely not standard of the industry that you have to record these, and there's no evidence and nothing has been given to the court. No, industry treatises, guidebooks, anything to indicate that this is standard in the industry. Even if it were, that doesn't trump the plain language of the statute. And here, as we've set forth with all of the canons of statutory construction, to read this new requirement into this detailed statutory scheme would violate every canon of statutory construction. And in addition to that, would violate the clear intent of the legislature, because we have the benefit here of a very clear statutory history. Section 12 and Section 14 were enacted, or were either enacted or amended at the same time. And they were in two consecutive sections of the act. Section 12, the legislature included a requirement that they record the copy of the complaint. Section 14, the very next section in the act, they did not. So there is simply no way that you can look at the legislative history and judge and draw the conclusion that the legislature just forgot that it was an oversight. This certainly was an omission, although the case law says even if it is an oversight, you can't just add in requirements.
All right, thank you.
Thank you.
Mr. DiNicola.
Good morning. May it please the court, my name is Jack DiNicola. I represent Arch Insurance Company in this appeal. The Superior Court correctly ruled that all provisions of the lien law, Chapter 254, apply equally to all those who seek protection under the lien law, whether against a fee simple owner, a lessee of a leasehold interest, or a lien bond surety. There are no special rules or exemptions for lien bond claimants. They too must follow all of the procedural steps, and this includes recording an attested copy of the complaint.
Can you answer for me the practical consequence of that, and who the other interested parties are, and what is the effect of not making that recording?
Well, I'll answer the last part first. The last part, the effect of not recording the complaint is that you fail to comply with the lien law, and your lien claim is dissolved.
Let's just grant
Who
you
is
that.
interested?
Yes, what's the
Who?
practical consequence?
What is the practical, why do we require the recording of the complaint?
Put it that way.
Okay. There are two parties or three parties that are interested in that. The first is the principal on the bond. That person or entity has indemnity obligations to the surety, and they have an interest in what is happening with that lien claim, a significant interest. And if you have an insolvent principal, they may not have control over the litigation. So we need to have that recording.
Can you be more specific? Give an example because, I mean, who are we talking about? Are we talking about the owner? Are we talking about don't just use principal. Give a specific example.
Okay. A surety bond has a surety and a principal. The principal is the party responsible to the surety that procures the bond. Right. In this case, it was the general contractor. 99 times out of 100, it is the general contractor. The owners don't do this. General contractors do. Subcontractors also do. General contractors have bonding programs where they get performance bonds, payment bonds, and lien bonds.
Why would the general contractor care whether this complaint is filed in the Registry of Deeds in a target bond context?
Because it is required by the lien law, number one.
That's circular.
And number two is if that principal is insolvent, assume that that principal is insolvent, the surety is taking over the defense of that case.
Then he's happy that that's happening, right? Because that's why he got the surety. That's why he got the bond in the first place, right?
Look, suretyship is not insurance. This isn't something where you pay a premium and then you're covered for loss. You pay a premium for them to issue the bond. You also sign a general indemnity agreement where if the surety suffers a loss, you pay. So this is not insurance. That's why the principal has a unique interest in this. That's why in the NES Rentals case, there was a specific reference that principals need to be put on record notice, and that's why we have the recording. So principals are number one, owners are number two.
But hold it, but so take it to the next step. Okay, so what's the value to the principal of having that recorded in the registry of deeds? What benefit does that person get from that?
Two things. First is they know the status of the claim. And number two is they know that if there is no complaint recorded, then they have a defense if that surety comes back to them looking for money.
Again, circular. It almost that you're assuming the result to provide the reason for doing it.
Well, no, this is how it's done. This is how it has been done, as this court has, asked Mr. Day. Everybody does it this way. Everybody records these contracts.
That doesn't
these
mean that the statute requires it. I think your brother did a good job showing, based on the canons of statutory construction, that it just isn't there. It's not in the section, it's found in other sections, but not this section, so help me with that.
There are two SJC cases that address this issue. The first is Valentine Lumber in 1957. Valentine Lumber,
But that's before the passage of Section 12 and Section 14, right?
but it involved a target lien bond, and the plaintiff there made the very same argument that the plaintiff here is making, that why does it matter? We have the lien bond. Why does it matter that we didn't record the subpoena in that point? And the court there said, it matters because that's what the statute says.
But that statute isn't the statute we're interpreting anymore.
It's very close to it, but the second case is the NES Rentals case. In that case, the Supreme Judicial Court was addressing an issue regarding a claim against a target lien bond, Section 14, and whether or not the amended complaint to bring that target lien bond surety into the case could relate back. In that case, Section 5 was cited 9 times. So, in my view, what that means is that all provisions of the lien law need to be read together.
But in that case, and I haven't read NES Rentals in a long time, but in that case, it's my recollection, you're trying to amend the original complaint, which needs to be filed. You're not amending a different complaint. You're dealing with the original one, which everyone conceded had to be filed, right?
That case dealt with whether or not the plaintiff complied with the 90-day time limitation in Section 14, because they served the 9A, they served the motion for leave under 9A, and they did it late. But in the analysis, the court cited Section 5 and said, look, Section 5 works in conjunction with the Section 14, and it also says other parties in interest can be brought into the case, and the SJC said in that case that other parties in interest include the lien bond surety. So you can't have one case, this NES Rentals case, talk about the interplay between 5 and 14, and then here, ignore it. Other than that, you got to look at the purpose of the lien law and what it actually does. Because I think a lot of times this gets glossed over, and I tried to make a point of this in the brief. The lien law is in derogation of the common law. It says that under certain circumstances, a third party can be responsible and liable for the debts of others, even though there's no contractual privity. That is a very unusual step, especially with an economic loss and breach of contract actions. Extremely unusual. There is no lien without this lien law. There is no liability for a supplier to a subcontractor, as CES is, to the owner without the mechanics lien. So it's a very unusual step. In order to protect those, and the quote from this court in NES Rentals, actually from this court in Tremont Tower, is in order to protect the owner and others, there are procedural steps that need to be taken. And that includes notice of contract on time. That includes statement of account on time, or actually filed, which wasn't in this case. That includes filing a complaint on time and recording. You need to make those steps. And what Section 14 does is that it explicitly preserves all defenses. Because if you didn't do that, if that wasn't the case, if you couldn't assert any defense, and it's not any substantive defense, it's any defense. If you couldn't do that, then no one would bond these lien claims off until the very end. And these construction projects would stop, because under Section 4, lien claimant, a sub or below, the owner or the lender can refuse to fund. So 14 is there to substitute the bond for the lien in terms of security and allow the project to keep going. But it also says that it should be treated the same as a fee simple owner who doesn't bond off a lien. There's no reason, there's no valid logical reason why a fee simple owner or a blanket lien bond surety should be treated differently, should have fewer defenses than a Section 14 lien bond surety. There's no reason for that. There's no reason in the brief of CES to support that. The other issue that this brings up is equitable subrogation, because we are dealing with the law of suretyship here. And it is a bedrock principle, the law of suretyship, that the surety stands in the shoes of its principal. The principal here would be the general contractor. Now, if you accept CES argument here, that principle would be void for purposes of Section 14 lien claims. And there's no valid reason for that either. The surety is entitled to assert any and all defenses of the principal. That's what 14 says. That's the law of suretyship. If we don't support that here.
Can I switch back for one second? I'm just reading NES while you're talking here. Section 14 has a commencement of action requirement, is that correct?
That's correct.
What is that requirement?
90 days after the later of the required recording of the statement of account under Section 8
Right.
or receipt of the recorded bond.
Right. So Section 14 does have something that relates back to that original complaint, right? No. So when we're talking about the lien in section, the lien in NES, your view is I guess, Section 14 requires what to exactly happen? It requires a complaint to be filed on what?
It requires the complaint to be filed within 90 days of the latest of one of two things.
Go ahead.
One would be the recording of the statement of account, which is Section 8.
Right.
And the second is service of a recorded copy of the lien bond. So 90 days after the later of that, you must file your complaint or your lien claim will be dissolved. The lien's already dissolved by virtue of the recording of the bond. The lien claim is not. So here in 14, there's a specific statute of limitations issue there. Now, I can tell you also that there is,
And if the complaint is not timely filed, the lien is still dissolved.
correct,
The lien's dissolved in any event.
it is, but the liability is still there for the surety, that has to be judicially determined.
But if I'm looking doing a title search to see whether there's any liens on the property, why do I care whether or not a complaint has been filed on the target lien? Because the lien has already been dissolved. There's nothing that would interfere with my purchase of the property.
Once the target lien bond is recorded, it is not an encumbrance on the fee simple.
Right.
Anymore. We acknowledge that. Everyone knows that. Okay? However, that mechanism is set up to allow construction projects to continue in the face of a Section 4 notice of contract. And because this is getting a little bit beyond, but the Prompt Pay Act, which was recently introduced into legislation, voids conditional payment obligations unless you record a notice of contract before you submit your first application for payment. So pay if paid clauses for subs, if they want to enforce those, they have to put a notice of contract on before they submit their first application for payment. So what you're seeing here, in practical terms, is you're seeing notices of contract from subs on earlier in the project. Now, lenders can refuse to fund over that. The only way to address that, to allow the funding to continue, is these target lien bonds. But if this court determines that none of the substantive procedural requirements in the lien law are applicable to a Section 14 lien bond, we're going to have a problem. They either aren't going to issue these bonds, or the premiums are going to be humongous. The industry has been operating like this for several years. The 4 cases that I've attached to our brief are 4 from this project alone. That's it. This is how it's been done in the industry, and that is at least something that ought to be considered in making your decision.
Right, thank you.
Thank you very much.